Good evening, everyone. Thank you all for joining us today. Before we hear from our esteemed speaker, I would like to take this opportunity to share with you some of the questions that have drawn us to the issue that we will be discussing today. So as we all know, death penalty as a punishment bears an exceptional status within our criminal legal system. It is the only punishment for which our courts must provide special reasons before imposing such a sentence. Further, it is the only sentence that cannot be carried out until it has been confirmed by the high courts. These confirmation proceedings are seen as an extension of the trial, where the high court has the power to direct further inquiry or record additional evidence on any aspect bearing on the guilt of the defendant, as well as consider any material relevant to sentencing. Even the Supreme Court has repeatedly emphasized the need to reconsider the evidence on guilt as well as on sentence in capital appeals before itself, and has stated that a reasoned order must be passed in death matters while exercising its special leave jurisdiction or its SLP jurisdiction. Even in review jurisdiction, the court in 2014 created an extraordinary right of limited oral hearing, where while all other matters which are heard by the Supreme Court in review proceedings are in fact heard by circulation without any oral arguments before the judges, in death penalty matters since 2014, in review cases, the court will grant a limited oral hearing. This exceptional nature of the punishment also extends to all kinds of administrative remedies that are available for a prisoner sentenced to death, where they cannot be executed without a decision on their mercy petition by the state governor or the president. Now, the reason for accounting for and relaying all of the special procedure that is available in death penalty cases is that it is at this point that we start considering, or where we start asking ourselves, why is it that a special procedure and a special kind of fairness is demanded in death penalty cases? I believe the most obvious answer that we can come up with is that the right to life is the most sacrosanct right in our constitutional democracy. Death penalty, which irreversibly can extinguish life and therefore can deny an individual a chance to reform, is the reason why we have such a special procedure in our system. However, despite all these procedures, what we also find is that there are several infirmities within our legal system and that we see within the administration of the death penalty that deny the effect of these safeguards. Research on the administration of the death penalty in India shows that an overwhelming majority of those that receive the death sentence belong to socially and economically backward classes. Their marginalization is something which also has a direct impact on their ability to access adequate legal representation. From a judicial consistency and fairness perspective, data also shows us that from 2018 to 2020, in the trial courts across India, in 94% of the cases where the death sentence was eventually imposed by the trial courts, there was no material on sentence whatsoever, including any material on mitigation that was placed before the courts before the death sentence was imposed. So as we reflect on these aspects regarding the death penalty in India, there are three important questions that start to emerge. Firstly, is there something which is inherently different or unique about the nature of death penalty as a punishment that differentiates itself from all other forms of punishment, including the very severe punishment of life in prison? Secondly, should the standard of fairness that is demanded in cases that result in the death sentence be different from other criminal cases? And thirdly, are the issues regarding fairness in capital cases symptomatic of broader systemic concerns within our system? It is with these initial thoughts that I would leave you all today, and it's with these questions that we come to today's lecture. I would now like to take a few moments to also introduce the esteemed speaker that we have for this evening. Honorable Mr. Justice UU Lalit enrolled in the bar in 1983. He was designated as a senior advocate of the Supreme Court of India in 2004 and was elevated as a judge of the Supreme Court in 2014. He served as the 49th Chief Justice of India in 2022. As Sir mentioned, Justice Lalit's contribution to the jurisprudence on a wide range of constitutional and criminal justice issues, especially in matters relating to the death penalty, is undeniable. During his tenure, he decided several important death penalty cases. These include his notable dissent in the Constitution Bench decision in Union of India versus Sriharan in 2015, where the court upheld the constitutionality of a special category of sentences that may be imposed by high courts or Supreme Court to bar the grant of remission or premature release by the executive. Justice Lalit also headed the bench in Manoj and others versus State of Madhya Pradesh in May 2022, where the Supreme Court, for the first time, issued a whole range of practical guidelines to be followed by trial courts to ensure proper collection of material relevant for sentencing, especially information relating to the mitigating circumstances of the defendant. Most significantly, in September 2022, as the Chief Justice, he headed a bench of former Justice Ravindra Bhatt and Justice Sudhanshu Dhulia, which noted the lack of a uniform framework in capital sentencing and referred the matter to a 5-judge bench of the Supreme Court towards ensuring a real and meaningful opportunity being granted to defendants in capital cases. This matter would be the first in over 4 decades where a constitution bench of 5 judges of the Supreme Court would be considering issues of fair procedure in death penalty sentencing. Considering his unparalleled contributions to death penalty law, we believe that there can be no other better person to illuminate us on this issue. With this, I am honored to invite Justice Lalit to deliver Project 39A's 6th annual lecture titled The Quixotic Search for Fairness, Death Penalty in India. So.
Right at the outset, I must express my apologies for being late for this program. I have heard submissions that delay defeats equity and especially in grant of death sentences. So Shatrughan Chauhan actually then carved out one area, but this is something unpardonable. I'm so sorry, there's something which was beyond my control. I'm extremely sorry, please pardon me. Well, distinguished persons on the dais, off the dais, there are many senior counsel who are present here, learned advocates who are present, and I see some of the students who are here. So this is to all of you. Well, I joined the bar in 1983. Around that time, while I was studying, came the judgment of the Supreme Court in Bachan Singh, 1980. 83 came 2 judgments, Vatishwaran and Sher Singh. Vatishwaran was a judgment by Justice Chinappa Reddy, saying that if there is any delay while the matter is pending in courts of law, the death convict would be entitled to have the death sentence commuted to life. Justice Chandrachud, that's Y.V. Chandrachud, Chief Justice, took a different view in Sher Singh, which was the reason why the matter then stood referred to Triveni Ben before a bench of 5 judges, but that's a different area altogether. If you see the history of death sentence and this fairness doctrine, which is now getting incorporated at every juncture, the history perhaps I think should start from 1973 when The statute now requires special reasons to be given in matters where death sentence is to be awarded. And the shift from the normal sentencing regime that death sentence would be the norm and life sentence would be the exception. It was the reversal, complete reversal, that is life sentence being the norm and death sentence being the exception. So to my mind, this ethos starts with that 1973. So let's put it 73 to today's 2023. We have traveled 50 years since then. First decade of 10 years, 1973 to 83, what we had, wonderful judgments. Number one, Maneka Gandhi, which introduced for the first time fairness as one of the attributes of right to life, and due process, following due process, being part of what is your right to life under Article 21. So that gave a new dimension. Then comes the judgment in Bachan Singh, 1980, where the validity, whether death sentence could validly be granted or not, was the basic question before the bench of 5 judges. The majority judgment accepted that yes, it can be. The dissenting opinion being by Justice Bhagwati, which spoke to the contra. And the majority said that yes, very well, death sentence can be granted provided certain kind of safeguards are read into the entire process. And some of those safeguards were that very well you take into account what are the aggravating circumstances and at the same time the mitigating factors, and then consider whether the death sentence becomes the imperative or not. So this logic or the idea that mitigating circumstances or mitigating factors must also be taken into account starts with that Bachan Singh. This was then followed by Justice M.P. Thakkar in Machi Singh. Machi Singh is an extension of the same idea. But post Bachan Singh, the very great imperative which must always be part of the decision-making process was to locate, analyze, and consider these mitigating factors or circumstances. And there are certain lines and passages in Bachan Singh which actually go to show that the burden to prove these mitigating factors or to place on record would normally be on the prosecution rather than on the accused. So that's completely a reverse burden on the prosecution. And rightly so, because right from a matter where somebody gets arrested in a capital offense, his liberty would be curtailed, and he would not be in a position, in a situation, to place all the material before the concerned court. So therefore, 73, then comes Maneka Gandhi, then Bachan Singh, Machi Singh, and then in that first decade of 73 to 83 comes the judgment of Justice Chinnapareddy in Vattishwaran, and also the judgment of Justice Chandrachud in Sher Singh. So these are the important judgments which came in that decade, and that decade synchronized with my joining the profession in 1983. Very well. As a lawyer, my first brush with a death sentence matter was in General Vaidya assassination case, where I was part of the team which was the prosecution team. I was part of the CBI team to work in the matter. Those two persons were sentenced to death by the first court, that's Tata Court, and the appeal lay directly before the Supreme Court. The Supreme Court confirmed it. Those two persons were then, they never sort of even filed a review against that. They never even filed an appeal against their own conviction by the first court. The matter came by way of confirmation before the Supreme Court because under the provisions of TADA, the modified application of CRPC, the confirmation, there is no High Court, so the matter came directly before the Supreme Court. Then you have one case which was that Simranjit Singh Maan, who wanted to file a review petition on behalf of these two persons, which the judges or the bench did not entertain it, saying that the matter hasn't been filed by the person concerned, the aggrieved party, and therefore the review got dismissed. So that was my first brush with the first death sentence matter, which I did as a lawyer. Over a period of time, I have seen many, many cases, and especially now I'll come to, out of these 50 years, the last decade, which starts with 2013. From 2013 till 2023, 10 years, out of which I was a judge of the court for 8 years and 3 months. So major part of that, I was part of the court as a judge. In that period of 2013 till 2023, there are landmark judgments, and just consider how the matter or how the progress has been seen in last 50 years. The first judgment to my mind would be Shatrughan Chauhan, which is Justice Sathasivan's judgment, where in a case where you are dealing with mercy petitions and you are considering post-confirmation of death sentence issues or circumstances, he culled out various circumstances or various factors which could be the basis to commute the sentence from death sentence to life. And some of the factors which he notices in those judgments, in that judgment, one factor was solitary confinement. The other factor, of course, was delay in considering the mercy petition which has been preferred by or on behalf of such a person. Mind you, if you study the judgment of Sunil Batra was the first judgment where solitary confinement as an issue came up before the court. And Justice D.A. Desai's judgment, it actually sums up everything to say that solitary confinement can be or can be taken resort to only after confirmation by all the courts of the death sentence to be awarded to the person concerned. After the first court's judgment or decision saying that so-and-so is held guilty and be sentenced to death sentence, there can't be segregation, there cannot be confinement in a solitary confinement. So that's the sum and substance of Sunil Batra. Sunil Batra, the foundation is considered in Shatrughan Chauhan, but Shatrughan Chauhan did not grant benefit to anybody on the ground of solitary confinement. It granted benefit to persons on the ground that there is delay in considering mercy petition, or there was lunacy, or there were such factors which were post-confirmation factors which were presented before the court. So therefore the first judgment comes is the Shatrughan Chauhan, 2014, sometime in February, March. Then July, August comes another landmark judgment in 2014, which is Muhammad Arif. Justice Rohinton Nariman speaking for the majority, 4:1, saying that every review petition filed where a person has been convicted and sentenced for death must be listed in open court rather than being considered by circulation, and there must be at least half an hour oral hearing in the matter, and that too by a bench of 3 judges. Now, mind you, in Supreme Court, normally all these matters are never taken by a bench of 3 judges. The initial appeals, they're always listed before a bench of 2 judges. So we had a peculiar situation that the initial appeal could be listed before a bench of 2, but the review had to be listed before a bench of 3. So then the issue came up whether is this bench of 3 judges sitting in appeal over the decision of 2, so therefore rather than to obviate that, a practice direction got evolved in the Supreme Court saying that the main appeal itself be listed before a bench of 3 judges. So that's how every judgment, every decision, then the fallout or the consequences are that you try to refine the process which has up till now been adopted by the court. So therefore, to my mind, the second judgment would be as Muhammad Arif. Then comes another judgment where what was stated by Shreya, that is Sri Haran's judgment. I had represented state of Karnataka in that Swami Shraddhanand matter, where a bench of 3 judges gave commuted death sentence and converted it to life with a rider that the person cannot be given the benefit of remission for till the end of his life. In Shraddhanand, it was worded like that. So the validity of or the correctness of this kind of sentence which is to be imposed on an accused came up for consideration before a bench of 5 judges. Of course, it's my dissenting note on the point, but 3 judges, the majority judgment says that yes, you can convert, you can commute the sentence from death to life with a rider that there shall not be remission or commutation of sentence for a fixed term or even till the last breath of that man. My dissent was on the point. I said such a sentence is not sanctified by the statute. If you compare it with some of the other amendments to the Indian Penal Code, which were effected in the year 2013-14, around that time, where 376 offenses, it was specifically stated that the life sentence shall be till the last breath of the man. Then second point on which I dissented was, if you consider it to be the sentence, then it must be open to the trial court also to award that kind of sentence. And in a given case, if the trial court were to award a sentence saying that life sentence without remission, the matter would not come up for confirmation before the court. And if the man doesn't file an appeal, the correctness of that sentence will never be gone into by any court. And third, according to me, at times, if you convict somebody and put him in jail without there being a ray of hope, then that would actually be a far harsher sentence than death sentence. So while saying that we are trying to have a midway between the death and life, you are actually creating a situation where perhaps it could be harsher for the man concerned. Of course, that's my dissenting note, and Justice Sapre joined me in that. Justice Khalifullah, speaking for the majority, felt other way. So therefore, that's the law of the land today. Sri Haran is the law of the land. So therefore, that came sometime in 2017, etc. Then some of the decisions which Shreya referred to. And that's where logically we started thinking on those lines while sitting in a bench of three and considering these matters which came up by way of an appeal before us. That when you say under Bachan Singh law, mitigating circumstances must be noted, considered, and weighed, shouldn't it be the obligation on part of the prosecution, because this is what Bachan Singh says? Then put it in practice. How does one put it in practice? And that is the reason why those practice directions then started getting issued by us, not in one matter, but number of matters. Then I also recollect Shreya herself appeared before us saying that in order to collect the mitigating circumstances, allow us to have an interview with the accused concerned. So we started repeatedly passing those kind of orders that yes, very well, let there be interview with the person concerned. Therefore, these orders started getting passed. Then finally came the judgment in Manoj, where certain guidelines were issued by the court. And then, of course, what Shreya mentioned, the matter is now referred to a bench of 5 judges. So on the procedural fairness part, after Bachan Singh, it would be the first sort of case before a bench of 5 judges. This is why, according to me, in these 50 years, starting from 1973 to 2023, the first decade and the last decade assume great significance. Very well, this is something just going by the historical perspective. When we normally speak of death sentence, and any discussion about death sentence would normally be on 2 planks. Number 1, validity of that death sentence. Should the death sentence be awarded or not, as a principle, as a normative basis, as a guideline? That's your first idea. Whether in principle should we award death sentence or not. And that's exactly the matter was visited by a bench of 5 judges in Bachan Singh. We have some of the other cases where under 303 there used to be a mandatory death sentence. So therefore, whether as a matter of law, again there can be a mandatory requirement of death sentence. The Supreme Court intervened and said that sorry, it cannot be. There has to be a discretion. Judicial discretion must come into play. It can't be statutory mandate. So therefore, we are in that realm or in the first part where what we say is that whether death sentence should be awarded or not. There are certain judgments, like for instance, Justice Sinha in one of the judgments said that in circumstantial evidence matters, death sentence need not be or should not be granted. Again, the ethos, why? Because what you, at the back of your mind, you always have one thought, and that is, thought is, death sentence is irreversible. The moment it is executed, the man is gone. Even if there be any fresh material or additional material which may come to the notice of everybody after that, the situation would be irreversible. By very nature, circumstantial evidence cases are such where you are drawing an inference on the basis of circumstances rather than being a case of direct evidence. A direct evidence case would be somebody speaks on oath saying that yes, I saw this, which was getting unfolded before me. And therefore the logic which prevailed with Justice Sinha in some of these matters was that in circumstantial evidence cases, it should not be granted. But of course, there is another school of thought which says that circumstantial evidence cases are as good as any other case. And the standard of proof that you apply is everything must be proved beyond reasonable doubt. So if the circumstances prove that, going by the logic which was, if you recollect that Sharad Birdichan Sarda, that those 5 principles, that if there is circumstances which provide a chain, which is there is unbroken, and it points only in one direction, that's the guilt of the man, then why not? So therefore, these are 2 schools of thought on that basis. And in one of my judgments, I accepted the fact that even in circumstantial evidence cases, death sentence can be granted. You may not grant, that's a different thing, but not as a matter of law or as a matter of rule. So this is what one can see in the first compartment, where you are going on validity of that death sentence to be awarded as a matter of principle or as a matter of practice. Then we come to the next level, which is individual cases where you may try to now come to terms and say that whether in this case death sentence be awarded or not. So rather than on normative level, you are now on an individual level, whether the facts and circumstances of the case justify the award of death sentence or not. And it is in this area that the entire fairness doctrine has developed. So whether should we award death sentence in an individual matter or not, certain principles over a period of time have developed, have been accepted, and have become part of our jurisprudence. Now let us start with that. You know, I used to be the chairperson of NALSA for about 15 months, and in that capacity, because this is Project 39A, and 39A is nothing but legal aid. So therefore, NALSA used to be conducting various seminars. I have traveled length and breadth of the country in order to do that, in order to spread the awareness. And what I found was that on the criminal side, at least 75% cases are those where the persons concerned are below poverty line. And they definitely require legal aid. But most of them, if you go by that logic, then 75% of those people must be part of the legal aid dossier. They must be part of legal aid regime. But the legal aid is availed of by not more than 12% of people who are actually facing criminal prosecution. So where do these people go, 12 to 75? The difference between these 2 numbers. And that's where we need to arrest that. And that's where, as a legal community, we need to find some solutions and extend our helping hand to those persons. Because most of them actually land up selling their assets, selling their lands, jewelry of their wives, and then try to garner some resources and then have the legal kind of services from, paid legal services from some of those persons. So therefore, when we speak of fairness, let us start from the very first stage of fairness. Number 1, whenever a person is arraigned as an accused, whenever he is taken in custody or not. Naturally, there are judgments on the point, D.K. Basu down the line, that in what cases the custody can be taken very well. So therefore, we need not bother about that. That fairness doctrine has already been incorporated as part of your approach to the matters. Done. Then the next level. What should be the approach of the investigator? And that's where one must actually then consider that judgment in Manu Vasisht which was that Jessica Lal murder case. There in 2 paragraphs, the court has actually beautifully summed up the idea. And it says that during the course of investigation, if some material comes in the custody of the investigator, which has the potential to help the accused rather than help the prosecution, then the fairness demands that that material must be made available to the accused. Because prosecution is not something, it's a game to be sort of, undertaken. The whole concept or the underlying idea is to reach the truth. If the idea is to reach the truth, if the idea is to see that, the truth prevails, then it is equally obligatory upon the investigating machinery to share the material which they have come across during the course of investigation. Say, for instance, in a rape and murder charge, if the body fluids which are found inside the body, dead body, do not indicate that the source of that material is something which gets matched with the accused person. Now, the accused will not have that kind of wherewithal to command or have the resources to get that material. It is only the prosecuting agency or the investigators who will have the custody of such material. If that material gets suppressed, will we be having truth prevailing in the matter, or will we be having just a game where you want to sort of, defeat the theory that the accused is innocent? And that is precisely why that judgment has, according to me, great significance. That you must share the material, whatever comes in your custody, with the accused. The same logic or same ethos then prevailed in that V. Sasikala matter, where Justice Gogoi was, of course, that was not a death sentence matter, it was pure and simple Prevention of Corruption Act matter. But the idea is something which is getting carried. And that is another significant contribution in last few years, so far as that death sentence issues and matters are concerned. Then third, we now come to the level of, we have dealt with the arrest, etc., then we come to the investigating part, and now we come to the third level, which is the prosecutor's level. In one of my judgments, which was that Anokhi Lal, the entire matter was completed within 12 days from the filing of the charge sheet and the sentence. So filing of the charge sheet, submission of oral and whatever submissions, examination of witnesses, and the judgment within 12 days. There's another case where it was done in 15 days. It appeared as if, there was a rat race in some of the sessions court coming from a particular state. And we had an occasion to consider why is it happening so? There's an internal circular which was as if, commendation to the prosecutor that he is getting the death sentence in no matter of time. And that would be taken as an honor or as an award to the prosecutor. So we had to deprecate that practice. State of that particular state, I won't name that state, but that state was obliged to withdraw all those kind of circulars. And that's where the role of the prosecutor actually becomes very, very clear. What is that prosecutor supposed to do? The fairness demands it, that he is representing the societal cause. The societal cause is reach the truth. Not that this man must be punished. If the truth says that he is guilty, then certainly, yes, the consequence must follow. Now, that's the third level at which we have incorporated the fairness doctrine in the entire approach. the fourth. Now, so far as the trial courts are concerned. Apart from this idea that special reasons be given, there's one beautiful provision in the CRPC which says that the accused must be given chance to respond or to give his reply on the issue of sentence. And he must be given adequate opportunity. Mind you, there have been cases where without even affording any such opportunity, on same day, death sentence was awarded to certain accused. And that's where the fairness on part of the court then becomes evident. In one of the cases, I still recollect Justice A.K. Ganguly's bench was confronted with this kind of situation where the death sentence was awarded the same day as on the day when the conviction judgment was rendered. And on this ground alone, that bench commuted the death sentence to life. But there are other judgments also which say that, yes, such a thing can be granted, provided no prejudice has been caused to the accused. Now, very difficult to prove what kind of prejudice has been caused to the accused. But yes, I must say that as a student of law, there are two streams or two lines of judgment, which one says Justice Ganguly and that kind of logic, and where on the other side that yes, it can be done even on the same day. But this is one part where the trial courts must be very, very vigilant. And now come to the directions that we have passed, that it will be part of the trial court's obligations to consider what are the mitigating circumstances, to elicit them. Then it will be an additional burden on the trial court in such matters to see that some of the mitigating circumstances are brought on record. I must tell you that while dealing with that matter, one thought which occurred to us is, at what stage does the trial court embark on this inquiry? Should it do it after it comes to the conclusion that the man is guilty? Or should it do it right in the beginning? Right in the beginning, the advantages are numerous. You will be able to see the psychological frame of that man. You'll be able to see whether there is any kind of psychiatric ailment or something with which he is suffering from. If you postpone it to the last date, in the meantime, 3 or 4 years gap may have arisen. The situational kind of differences will always be percolating. So your assessment on the last day would not be so effective as it would be on the first day. But supposing if it is to be on the first day, in most of these matters, persons may get acquitted. So where does one draw the line? And that is where, that's one area which is still bothering us, but we said that very well, let the trial court do it at the last level. Maybe progressively the matter can still be gone into and some refinement can be put in place. But the logic which now has been part of our jurisprudence is that the trial courts must embark on this inquiry. And therefore, the trial courts are now supposed to be the torchbearers of the truth, that you must get that truth. The torchbearers of the truth, in one form, you must have all the material. So therefore, solicit all the material. Get it recorded, put it on record, give it the copies to the other side. That's what in Sasikala Justice Gogoi said, that give inspection to the persons concerned. So therefore, that's where you go to the length of saying that he must be made aware. And that's what the logic now goes to the level of trial court must actually be extra vigilant. Apart from the fact that special reasons by statute must be incorporated. Very well, so therefore trial court. Then comes the confirmation court in case death sentence is awarded. At that level, in one of my judgments, which was Anokhi Lal, again the same thing, I emphasized the fact that, there's a very beautiful saying by Justice Krishna Iyer. Legal aid to the poor does not mean poor legal aid. So therefore, in case you want to extend legal aid as a concept to certain persons who are disadvantaged, then let it be quality legal aid. And quality legal aid in matters where person is facing possibility of death sentence must be of a different dimension. And therefore, in that Anokhi Lal, again the same principle which was initially Hoscourt, which was Justice Krishna Iyer, that legal aid is part of your Article 21. So therefore, we said in Anokhi Lal that the person concerned who gets appointed as a legal aid counsel must have had at least 10 years standing at the bar. So therefore, you get some kind of quality assistance, not just any kind of matter. And this is where we try to bring in, by every possible way, the element of fairness. And this is how it gets incorporated at the trial court, at the appellate court, that is the confirmation court level as well. Though it is true that Vatishwaran said that delay during the course of matter before the courts is not to be considered as a factor to commute death sentence to life, yet the approach has always been to see that these matters are dealt with at an early date. They are fast-tracked as against the other kind of matters. So the confirmation matters again go in that direction. Very well. After the High Court, the matters come to Supreme Court. At the level of the Supreme Court, again, in case these exercises are not undertaken, we have always, as judges of the court, we always extended that and said that very well, we will consider the material at this juncture. Of course, there is a possibility that perhaps I think the material may be qualitatively different. But at least, we are receptive enough to say that very well, let the material be placed on record. And last few orders which the Supreme Court has passed are testimony to the fact that those mitigating circumstances must always be borne in mind, must always be part of the record. Now, this is how the approach of the courts at every level is getting refined. And refined for what? Refined only and only to see that the man who is facing the possibility of death sentence must be given the adequate kind of representation and every fair opportunity to represent himself. Now, coming back to one of the judgments which I told you about, this Sunil Batra. So therefore, after the Supreme Court, now comes the next level, which is the execution of death sentence. Again, the law which has developed is that in case there is extreme delay in execution of death sentence, the Supreme Court says that death sentence be commuted to life. So even in cases where there is a definite finding that the man is guilty and deserves to be given death sentence by courts of law, if there is no execution in the shortest possible time, or if there is no consideration of the mercy petitions in shortest possible time, then there will be a ground available to the person concerned to seek commutation from death to life. So even after the final finding by the Supreme Court, there is still a possibility. And that's where, again, another fairness doctrine seeps in. So that's where you see that Shatrughan Chauhan, that's the logic. And Shatrughan Chauhan goes to the extent of cataloging what are the possible ideas or compartments under which the commutation can be effected. Now I must tell you, solitary confinement. Solitary confinement, Sunil Batra, yes, but no relief on that count. Logic has been expounded, logic becomes part of our jurisprudence, but no relief. Shatrughan Chauhan accepted as a principle, but no relief. Then I had an occasion to consider in Ajay Pal, where the man was putting forth his case on two grounds after the death sentence was confirmed by the Supreme Court and everything had happened. One, delay in considering his mercy petition, and two, that he was kept in solitary confinement. As a judge, I was confronted with this. See, I'll tell you, as a judge, I must have dealt with at least 25 death sentence matters. I confirmed death sentence in only two. One where the man was guilty of raping and murdering a 4-year-old child, and the other, which was actually Lal Killa, the terrorist attack case. In all other matters, the conscience of a judge must actually get satisfied to a very different level, that very well, this is where that life needs to be extinguished. Because that's a very extreme power which is given to a judge. Amongst the fellow citizens, you are given the power to terminate the life of a fellow citizen. And that power, therefore, the judges exercise with extreme caution, with extreme kind of, circumspection. And that is where, when these two grounds were projected before us, I was confronted with the idea that should I go by Sunil Batra law? Or should I go by this logic that there has been delay in considering mercy petition? I put it on both counts. And therefore we commuted that sentence to life. Very well. That was a bench of 3 judges where it was, I think, Justice Deepak Mishra presiding over the bench, but judgment is mine, authored by me. Then recently in 2022, just before my retirement, there was one judgment which was B.A. Umesh, again coming from Karnataka. And mind you, B.A. Umesh, the original judgment of 3 judges had rejected the idea that death sentence must be commuted to life because sentence was awarded the same day. So this is a contra idea rather than Justice Ganguly's idea. So therefore, that belonged to the second category of cases where the judges said it doesn't matter whether the sentence is awarded the same day. So B.A. Umesh was part of that. But even after the death sentence, there was delay in considering mercy petition, and therefore the gentleman filed a writ petition in the High Court which got rejected and therefore came before us by way of an appeal. 2 grounds again projected. Number 1, solitary confinement, and number 2, delay in considering representation. Now this time I rejected the second ground, delay in considering, but accepted the first ground and commuted the death sentence to life. So therefore, look at how, to what extent the jurisprudence is now developing. That even if a man has been kept in solitary confinement against the diktat, against the mandate, against the law laid down by the Supreme Court. See, normally in death sentence matters, who are the principal players? The courts And the executive, which is given the power under the Constitution to commute the sentence, where do these police officers come? And any infraction on their part, should it entail in commuting the death sentence to life? But we accepted it as a fact, the reason being, for number of years the man was kept in solitary confinement. It was not few weeks or few months. It was number of years, and accepted fact. And that's where the courts are now incorporating doctrine of fairness even at post-conviction stage. And therefore the logic is very, very clear. The statistics are also very self-evident. The statistics go to show that in most of the matters, for instance, after Muhammad Arif, when the review petitions had to be listed before bench of 3 judges, there were cases where review petitions were already dismissed by a bench of 2 judges who had initially heard the matter. Yet, the benefit of Muhammad Arif was given under the orders of the Supreme Court, and the matters were again listed before another bench of 3 judges. And there are cases where even when the initial appeal was dismissed, initial review petition was dismissed, in the second round of review, people were granted benefit and death sentence was commuted to life. That, to my mind, is the greatest achievement by the Supreme Court in last few years. That it is seeing death sentence matters, death sentence, death convicts, with a different kind of, compassionate idea. It is not being seen as a pure run-of-the-mill matters. These matters are seen with special caution. And that caution is exhibited at every juncture. It is evident at every juncture. And that, to my mind, is greatest tribute to Bachchan Singh in last 50 years. So that's where the fairness doctrine, which got evolved as a matter of law in Bachchan Singh, that at every juncture let there be fairness, is now you are able to see it at every level. And this, to my mind, is the fairness at its highest levels. You won't find anywhere else in any other country. There are other principles, yes, which we may accept, we may not accept, especially in jury trials. But this is what, to my mind, is the greatest contribution by our jurisprudence. And I'm really proud of it, that I was part of that at some juncture or the other, at least as a judge or as a lawyer, or maybe even as a student of law. And that, to my mind, should be a matter of pride for all of us. Thank you so much.
Thank you so much, Justice Lalit, for taking us through that constitutional journey and the journey of fairness in the administration of the death penalty, and demonstrating the constant struggle and the constant need to look out for fairness in the administration of the death penalty, right? And I think and I think that effort is an acknowledgement of the constant need to, as you said, to refine the ideas of justice and fairness in this concept. And I think it is evident that the Supreme Court's approach to the death penalty is very different from what is happening in the trial courts, right? And I think the most stark statistic on that is that after the ruling in Manoj, and what has happened in the trial courts, and the sort of very disappointing and complete non-compliance with Manoj in the trial courts is a cause for immense challenge, and how We address that in over nearly 150 death sentences that trial courts have given after Manoj. I think it is easily about 97 to 98% of those cases do not follow, if you look at the trial court judgments, do not follow the guidelines in Manoj. And that represents a certain challenge for fairness in how do we implement the doctrines. And I think all of that will take time. Systems take time to respond to these changes, build the necessary systems and processes to implement this. And a lot of stakeholders have a role to play in that. And thank you so much for so clearly delineating the challenges of fairness at every stage of the criminal justice process. And I think just like you highlighted the point with what happened in review cases post-Arif, as to what happened in those cases and the proportion of reversals in reviews, of already decided reviews, is quite startling. And I think the same challenge presents ourselves in light of the guidelines in Manoj as well, of what of cases where the Supreme Court has already confirmed the death sentence, and even the mercy petitions have been rejected in those cases, where the kind of effort that has been made since Manoj to collect mitigation information has not happened in those cases. Cases like, cases from Chhattisgarh, Maharashtra, like Dupare, what will happen to those cases? And I think there is going to be that question of what of the retrospective application of the guidelines in Manoj to collect the kind of mitigation information that has not been collected in cases that have gone past the Supreme Court already. And and before I move to the Q&A, I was reminded of, as Justice Lalit was, and I really like the manner in which you tracked your own journey as a lawyer alongside the evolution of death penalty jurisprudence, and the constant effort to make the death penalty fairer. I was reminded of Justice Blackmun's journey in the Supreme Court of the United States, where in 1972, when the US Supreme Court held all of death penalty laws unconstitutional of the US states, Justice Blackmun was in the minority in 1972 and disagreed with the finding of unconstitutionality, was amongst the 4 judges that dissented. And for 25 years in the US Supreme Court, Blackmun constantly strived to make the death penalty fairer, until in 1994, in one of his last judgments in the US Supreme Court, in Callins versus Collins, he said that his search for fairness in administering the death penalty has ended. And he has realized that perhaps there is no constitutionally permissible way to administer the death penalty. And he ended with the famous words that I shall no longer tinker with the machinery of death, right? So that, and I think that journey, and Blackmun was quite intuitive to say that perhaps he would not see the collapse of the death penalty in the United States in his lifetime, and he did not, right? But he said that day would come, right? And that day eventually has to come when we realize perhaps that the search for fairness is a constant one, and we'll perhaps never get there, where we are sufficiently happy with how much fairness we have achieved in the administration of the death penalty. So thank you so much for making us reflect on what an incredible journey this jurisprudence has taken, the effort of the court to constantly strive for fairness in different aspects. And I think that somewhere speaks to the challenge of finding fairness in such a difficult issue where the stakes are so high, and the conscience of judges, we got an insight into how judges think about this, can be so difficult and so demanding. So thank you so much for enlightening us with that, sir, and has given us a lot of food for thought. Just very quickly going to take some questions, sir, if you're okay with that. So I think there are mics in both the aisles with Uday and Komal. So if we can start with, yes, if, just give us your name and where you're from, and so that we have some context. And let's just keep the question short so that everybody has a chance to ask. Yes, please go ahead.
Good evening, sir. I am Harsimran Kaur from HNLU. I am pursuing 4th year in my law journey. Sir, my question particularly relates to the fact that you talked about how the higher courts, while the sentence being confirmed, are also reversing the sentences. So say if the trial court is convicting someone with death sentence, the higher court at times is giving life imprisonment or even a lower sentence. So sir, as you also quoted Justice Krishna Iyer, I would also like to present one quote by him. He says that every saint has a past and every sinner has a future. So when there is a convict who has already been sentenced as a death penalty in a trial court, in a lower court, and now this sentence has been changed, how does the look of the society is the same? We look him as if he is the one who was convicted for death sentence. And even as legal students, or when we pursue law further or become advocates, how can we help such people who have already been convicted with death and now their sentences have been reformed? I was just thinking about it, like what after this?
Yeah.
When we talk about fairness, we
We'll
also
take
take
that
into
one.
regard
Got
the
it.
restorative justice.
Got it.
That's it. Thank you, sir.
So, yes, yes, sir. Yes, it's on, sir.
See, that idea that every sinner has a future and every saint had the past, you're right there, but it is very difficult to incorporate these kind of principles in your everyday life and especially in criminal administration of justice. See, on one side, it is true that we are repeatedly and every time going a step forward to see that death sentence are granted in least possible cases. Now see, around the same time, the statutory developments. Our parliament has now incorporated under 376A and 376E possibility of a death sentence even when there is no sort of culpable homicide amounting to murder, or even when under 376E the person concerned is still alive, maybe in vegetative state, or under POXO, if a child or a minor is actually subjected to rape, even in such cases death sentence can be awarded. So therefore, every time the societal demand or cry for justice also is that in certain matters death sentence be awarded. Now that's the balance which the judiciary has to strike. So we can't just abandon and say that very well we will not grant death sentence in any matter. Then what happens to those statutory intendments? They're also part, this is something which our parliament has come out with, our representatives, yours and mine, they have thought fit that this kind of laws must be put in place. So therefore one has to strive to have a balance between the two. So therefore that's why when I refer to two compartments, validity of death sentence is one part, and whether in a particular matter should it be granted or not is one part. So therefore we try to look into the matter which is the second category matter. But of course at the back of your mind it will always be a possibility that yes, death sentence can be awarded. Doesn't mean that it must be awarded. So therefore we try to find whether there are any circumstances which would justify a non-grant of death sentence. And that's exactly the logic which comes from Bachan Singh, that you need to consider, you need to balance everything. So therefore, this is what the approach as a judge one has to have. It may be that that particular logic that every saint has a past may be something, but that can't get incorporated so easily, correct?
Just want to highlight one statistic here, sir, that over the last 2 decades, if you see what has happened to trial court death sentences, and that continues even to this day, that for every 100 death sentences that trial courts give, and this is a 2-decade statistic, about 35 to 40% are converted into acquittals, ultimately, and a further 55% are commuted. Right?
That's why I write in my, in speech I said that I must have dealt with 25 different
Exactly,
death sentence matters. In how many matters did I actually did I confirm death sentence? Only in 2. What does that mean? In 23 matters, there was either acquittal or commutation to life. To the best of my recollection, there have been at least 5 cases where I've acquitted people.
Yes.
So therefore, it happens. Now, that's the beauty of our system, where whatever the trial court says is not final on facts. Whereas certain other jurisprudences are, like especially United States, where whatever is determined as a fact becomes final. So therefore, to that extent, we must thank our jurisprudence that, yes, we still have some opening, some window where the matters can be corrected. Of course, that doesn't sort of, bypass the issue that perhaps the trial court should have been more circumspect.
Exactly.
Correct? That's a matter which perhaps is part of our continuing legal education, which we must undertake at the level of our national judicial academies and every place. That is true, that must be undertaken. And that actually is a very, very, very strenuous exercise. We need to overhaul the entire thinking process. Yes.
Yeah, in front. Yeah, Apurva, go ahead.
Hi, sir. My name is Apurva Mandhani. I work as a journalist with The Print, and I've written quite a bit about death penalty as well, of course, in collaboration with Anup and Shreya here. Now, I'll keep it really short, but I looked after your Manoj judgment. In fact, I looked at several trial court judgments that had awarded death penalties, 26 in total, awarding death penalty to 56 convicts, and I found that none of those judgments were actually following the guidelines in the Manoj judgment. And like you said, we've seen a change in outlook from the Supreme Court as well on how they're dealing with death sentences. But according to you, I'll keep the question really simple. How do you think we can ensure that these guidelines that the Supreme Court is giving out to ensure fairness in award of death penalties, how do these actually percolate down to the trial court, and why does it take so long for that to happen actually?
You're right. Perhaps I think there have been many a miss between cup and the lip. So therefore, the logical idea should be that these guidelines must get incorporated. At least the trial courts must be aware of these guidelines right from day one. But somehow maybe some administrative kind of machinery fault or infraction on their part, that these guidelines are perhaps not getting circulated before every court. Like D.K. Basu said that this judgment be brought to the notice of every police officer, and any infraction will amount to contempt of court. Perhaps I think a time has come to refine those guidelines and put additional imperatives. Number one, either to circulate those guidelines, to publicize those guidelines, to at least, how many trial courts must be there? There are 670 districts. Some of the districts may be having some additional sessions judge, about 1,000, correct? Circulate to those 1,000 courts which have the power to grant death sentence. So perhaps I think that should be the approach, and it should be brought to the notice of everybody. That reminds me of a beautiful incident. Do you know when slavery was abolished in US? For nearly 2.5 years, slavery continued in some southern states. What is called, Juneteenth. So therefore, that happens. At times it happens. But in today's world, there is no excuse. Today we have electronic media. Today the transmission can be so easy and so convenient. So therefore, that's no excuse to say that it should not be done by the trial courts. Trial courts must be aware of that, must incorporate those guidelines. So that's what I completely agree with you, that it must be done.
I snatched the mic away from the gentleman there, please.
Hello, sir. I am Mohammed Al Hassan. I'm from Faculty of Law, Jamia Millia Islamia. So my question to you, as you have pointed out, that the stage of fairness, that there is a prosecution side, it's the responsibility of the prosecution, and also the validity of the death sentence. Don't you think that the public perception regarding a criminal sometimes hinder in this thing? For example, the death sentence of Yaqub Memon. Out of the 11 people who were awarded death sentence by the trial courts in the bomb blast case, only his death sentence was upheld and he was hanged till death. There was a public perception against him. For example, I don't think so many people will know any of the names of the other 10 people whose death sentence were mitigated. So sometimes even the judges of the Honorable Supreme Court.
But the other death sentences to other 10 persons was commuted to life by whom?
So that was from the Supreme Court. But
That's right. So therefore, it's a judicial determination.
Yes, sir. My question was, there was just one perception regarding Yaqub Memon, that he's a brother of Tiger Memon. Therefore, the death sentence in the form of retribution
We
was
are
given.
not here to go into individual facts, correct? We go into the matter purely from the perspective as students of law. And as students of law, the judicial determination says that somebody must be given death sentence, somebody need not be given death sentence, correct? So therefore, that's where the separating line occurs. Now, once that separating line has been done by the adjudicatory body, then as a disciplined members of every society, we must accept it as a ruling, correct? Then we can't have any different ideas about the ruling itself, correct? So therefore, if there be perception, perhaps one can say that perception is wrong. Something which has repeatedly been seen by the court. Because to the best of my knowledge, that review petition or writ petitions were repeatedly filed before the Supreme Court, at least on 3 or 4 occasions. And yet, special benches after benches did not find any substance in the submission. So therefore, as a student of law, for me, that is what the final, truth which emerges out of that, okay?
We'll take 3 final questions, very short ones. Person there, then the person behind, yeah. And we'll end with Shoaib here. Yeah, please.
Thank you, sir. My name is Adya Nair. I'm a second-year law student at the National University of Advanced Legal Studies in Kochi. So my question was, how important do you think is the role of improving the physical infrastructure of courts in our country when it comes to ensuring a fair trial for persons accused of an offense which could end up in death penalty? Because many a times, I have personally seen how many persons accused of such an offense, such a grave offense, often stand at the end of the courts. They many times are not even able to hear what are the arguments advanced against them in the court of law. How important do you think is improving the physical infrastructure of our courts in that sense, so as to ensure that those accused are also being given a fair trial, a fair chance to understand what is happening against them in the court of law?
See, there can't be 2 opinions on the point that physical infrastructure must be of the top quality. So therefore, everybody accepts it as an idea. But the point is that at times there are resource crunches, there are sort of, shortcomings on that front, and therefore we don't find the resources getting translated into facilities at every level. But perhaps I think one can say that with the intervention, because this happens to be one of the major areas of concern and discussion when it comes to, Chief Justice's conference that we have on the administrative side. All the Chief Justices, along with Judges 2 and 3 of the respective courts, come here for a conference where the Chief Ministers of every state are also present. And then we sort out what are the demands of a particular state judicial service, what are the demands about infrastructure. So therefore, this has to get sorted out, perhaps for a country where we are still sort of struggling to go up on the economic front. Maybe we are still lagging behind, but that's an area where everybody is unanimous in the point that it must be completely sort of, of the first quality. Now, the other point that you say that perhaps the accused may be standing in a corner, then it should be actually part of the trial court's duty to say that, let this accused be in the forefront. He must sort of, be privy to what kind of evidence he is being led before the court. So therefore, that is something which the individual trial court must actually ensure, correct? Yes.
If you can keep the questions very short, please.
Absolutely. Good evening, everyone. I'm Professor Shireen Moti from OP Jindal Global University. Firstly, sir, thank you for such an outstanding lecture. It was really a treat to hear you speak so candidly about death penalty. My question to you, sir, is that there was this line that you said that the consciousness of a judge has to be satisfied to a higher level when it comes to cases of death penalty. So I'm intrigued by how challenging it was for you to decide such matters, and what are the kind of emotions that you went through when sitting on these matters. Thank you so much, sir.
And that is something completely personal. I'll tell you, the bench was Justice Deepak Mishra, Justice Rohinton Nariman, and me. Bench of 3 judges, which my first death sentence matter was heard by that bench. And the draft judgment is normally circulated, so therefore we were aware that what exactly would be the judgment. So on the day of the pronouncement, when all 3 of us were going together, this is what Justice Deepak Mishra said. I am being accompanied by a priest and a person who is well versed in criminal law. Now that's the assurance which Justice Deepak Mishra went by, that he's accompanied by 2 persons, one of whom is a trained priest, and the other is actually has done many matters on the criminal side. So therefore, when we do it, we always share our thoughts with the brother judges, and especially in Supreme Court, now it has to be a bench of 3 judges. So therefore, we circulate our thoughts, we share our thoughts, we share our opinions, we share our whatever touches our heart, and that's the process of determination. So therefore, take it that when the death sentence finally emerges out of this process, this crucible, take it that it has actually received a lot of attention at every juncture. Correct. And then what finally emerges is that fact. That is precisely why, even when I dealt with about 25 matters, confirmation was only in 2 matters, where I wasn't satisfied. Correct?
Just Lalit, if you just allow me to supplement as what has happened in Dupare after that, right? That we were, since after the confirmation, the mercy had to be filed, and for all those years now, we keep thinking now, especially after Manoj, what if the Manoj guidelines were there in Dupare,
See, I'll tell you, now if you look at Machi Singh, Machi Singh has developed the same principle as Bachan Singh, takes the matter further. But look at the last operative orders passed in individual matters in Machi Singh.
Yes.
In Machi Singh, there is one matter where a boy of 6 years was killed by the rival gang. And all of those persons were granted death sentence and confirmed by the Supreme Court. Now in today's world, I don't think perhaps that death sentence would have been granted. So therefore we always travel and we always try to refine ourselves. Correct? Now if we go by the same logic, that if Machi Singh was heard after Manoj guidelines, what would have been the situation? Perhaps yes.
Right. And that's the search for fairness.
That's right. Yes.
The last question. Sure.
Good evening, sir. I'm Shoaib Alam. I'm a lawyer. I've practiced before you. For everybody here who knows you only as Chief Justice Lalit, I must tell all of you that you're in the presence of greatness right now, with Justice Lalit being here. Your contribution to the field of law is immense. It's unparalleled in a way. And of course, to the very relevant topic that you've lectured us on today, it's a very educative experience for all of us. My question is something what my learned friend, my young friend here just mentioned, and it is about public perception. From a layman's perspective, on the judicial mind, how much of an influence is public perception from a victimological perspective? From the victim's point of view, how much is public perception and influence on the judicial mind is my query, sir.
I can speak for myself. So because now you are asking for how much it weighs on the mind of a judge. So therefore I can speak only for myself. You know, speaking personally, I don't read newspapers. I just flip the newspapers. You know, the headline, and that's good enough for me. So therefore, in 3 minutes flat, I finish 4 newspapers. And as somebody said that I'm like a fullback in a football, so therefore I first reverse the paper and start reading from the sports pages right up to the first page, correct? So therefore, I don't see any news channels. For me, the channels on TV are only sports channels and perhaps some of the entertainment channels. So therefore, for me, I'm not sort of, recipient of any kind of public opinion in any pending matter, correct? And at times it is true that yes, there is a definite attempt to generate a public opinion. At times, I'm saying, correct? But the judges have trained themselves. Now, most of the judges who come, they come with a great background as being the lawyers, as being judges for about fairly long period, half a dozen years at least, before they are, allowed to sit on the DB to preside over a criminal side matter. And before they come to Supreme Court, at least a dozen years of, experience. So therefore, they have trained themselves to be detached, to be sort of, aloof, or to be sort of, above all these kind of, logics. But it is true that at times, these kind of, one shouldn't say, but at times some of the news channels actually start it as some kind of a campaign, correct? And that campaign goes on not purely as the subject matter of the dispute before the court, but at times it gets personal also. So judges are also sort of human beings. It may get affected at times, yes, but speaking personally, it has never affected me. Thanks. Thank you.
Thank you so much, sir, for such a refreshing and candid interaction through the questions. And, just the vastness of the issues and the trajectory that the court has traveled on this issue. Thank you for putting it so well to all of us and making us think how much more of a journey there is to travel on the question of fairness in the context of the death penalty. Thank you for taking the time out, and I hope you will travel a little further distance and come to us on campus in Dwarka, right? And that our students can have the benefit of interacting with you. And to all of you, thank you for coming out on a Saturday evening. I'm sure you had many other options and social obligations, and you chose instead to spend time with us. It is truly appreciated. Thank you very much, and just join me in giving another round of applause for Justice Lalit, please. Yeah.
Well, your offer to come to the campus is accepted straight away. As it is, I am teaching at 4 places, so therefore, yes, and I love teaching. I love to interact with students, especially in the subjects that I have chosen. So therefore, it would be certainly one more institution, the more the merrier. Yes, thank you.